My name is Kim Martin, and I am a partner at the Atlanta office of Harrison and Held. My practice is devoted entirely to working with special needs families. I do special needs planning, guardianships, and I also work in consultation with families who are divorcing when there is a special needs child, particularly if child support is going to be paid. I've been doing this work for a while now, and I'm on the board of a number of organizations that provide help and support for intellectually and physically disabled adults and children. But I think my most important credential is that I am a special needs mom myself. My son Finn is 16, and he was diagnosed with autism 14 years ago. So that diagnosis caused me to reevaluate everything about my life, including the way that I wanted to practice law. And my son is the reason that I do the work that I do now. I have been asked to speak today about special needs planning. But before I get into that, I have to make my little disclaimer speech, which is nothing that I say today should be construed as legal advice. And this video is intended purely for educational purposes, and it's not a substitute for a meeting with a lawyer who knows your situation and who can give you advice about your specific set of facts. I also am not speaking on behalf of any local, state, or federal agency, and any opinions that I express in this talk are purely my own. So now that that's over, we can get on to our topic, which is special needs planning. This is a combination of estate planning and benefits planning. It's a pretty specialized thing to do. It's my favorite thing of all the different types of work that I do. If you're watching this video, it's probably because you have a family member who is receiving or hoping to receive means-tested benefits. And the most common means-tested benefits once our children turn 18 are SSI and Medicaid. So our kids can qualify for these benefits if they can meet the statutory definition of disabled. So for an adult, that means that they have some type of a condition that prevents them from engaging in what's called substantial gainful activity. You'll often hear it called SGA. And the SGA test is a dollar test. So if they are able to earn less than $1,350 a month because of some diagnosed condition that they have, or that's for non-blind adults. If they are a blind adult, then the SGA number is $2,260 a month. So if they are able to pass that test, if they are unable to engage in substantial gainful activity, that means that they have met the statutory definition of disabled. And you heard me say earlier that these benefits are means tested. They also have to pass the means test. And the means test is that the child needs to have less than $2,000 in non-exempt resources in their name. So assuming that they pass that means test and they meet the statutory definition of disabled, then they are very likely to qualify for SSI and Medicaid. Those are the two most common means-tested benefits. There are others. So food stamps, which is called SNAP in Georgia, is a means-tested benefit. Section 8 housing, which is federally subsidized housing, is also a means-tested benefit. But as I said, SSI and Medicaid are the two big ones. SSI is just a check that you get in the mail every month. It pays a monthly benefit that is supposed to be used first and foremost for food and shelter. The dollar amount of SSI changes every year. It adjusts upward for inflation, so it's always some strange number because it adjusts some random number of dollars every year. So for 2022, the SSI amount is $841 a month. And if the recipient of SSI has countable income from some source, either earnings from a job or potentially child support or any other source of income, then it could offset the SSI payment, and it will either potentially reduce the payment or even wipe it out altogether, just depending on how much how many dollars we have coming in income. In Georgia and in many other states, SSI is linked to Medicaid. So if you qualify for SSI, even if you just get $1 in SSI because you have offsets that reduce your SSI for various reasons, if you qualify for SSI, then you also qualify for Medicaid. Medicaid is a program that provides basic medical and hospital care. It also provides access to prescription drugs and sometimes long-term care. There are 7 different kinds of Medicaid. So as our children grow older, there will be various types of waivers that we hope to keep them qualified for. So we always care about the means test throughout our child's life. So Medicaid has a payback provision, which means if you are a Medicaid recipient, then at the end of your life, Medicaid will pursue what they call estate recovery. In Georgia, they often do not begin tallying these dollars until the child reaches age 55, except under certain circumstances. But that's one of many reasons why it's a good idea never to have a lot of assets in the name of your child, because at the end of the child's life, Medicaid is going to seek payback from whatever assets they have in their estate. So how do we plan for somebody who can never have more than $2,000 in non-exempt resources? This is the very child that most of us want to take care of the most. So the obvious, easy answer to that is that we leave our assets to the child in the form of a special needs trust. There are 2 big types of special needs trusts that are commonly used. They have 2 different jobs. You often will need both of them. You can't have one trust do both of these jobs. So these 2 trusts are called first-party special needs trusts and third-party special needs trusts. The first-party trust is a safety net. It's kind of a damage control trust. It's not a trust that you would want to use for estate planning. The third-party trust is the classic estate planning tool. So we're going to talk more about how these trusts work and the differences between them. But the big distinction between these trusts is the source of the funds. So the first-party trust holds first-party money, hence the name. You'll also sometimes hear these called self-settled trusts, or sometimes you'll hear them called D4A trusts. But the first-party trust holds assets and income that belong to the beneficiary. And an example of that type of resource would be a distribution from somebody who either dies without a will, if our special needs child is one of their intestate heirs, so the child just sort of involuntarily by operation of law inherits some money, or if some well-intentioned person who doesn't know what they're doing leaves assets directly to the child, sometimes grandparents are guilty of this, then that's first-party money. And if it's more than $2,000, it's going to disqualify the child from SSI and therefore Medicaid. First-party trusts are often used to hold settlements. So if there is an accident or some other situation where the child is receiving funds from a lawsuit, the court hopefully orders that those funds get placed in a first-party special needs trust. Sometimes the child is the beneficiary of a trust. Again, grandparents are often behind this. That is not a special needs trust. If the child is the beneficiary of a trust that is not a qualified special needs trust, again, we are left with first-party money. So the way to preserve the child's eligibility for benefits is to put those trust assets into a first-party special needs trust. Another thing that a first-party trust can be used for is to hold things like child support payments. Once our kids turn 18, child support can offset the child's SSI dollar for dollar after we disregard $20. So if the child support payments are high enough every month, they can wipe out SSI completely. And the way that we avoid that from happening is we direct in our settlement agreement that the child support payments must be paid to the trustee of a first-party special needs trust. So these trusts are creatures of statute. They are very heavily regulated and they're watched very closely by Medicaid. There are not a lot of choices about how we can create this trust or how we can administer this trust because it is a statutorily created trust. So first-party trusts can only be created by a parent, a grandparent, a guardian or conservator with the permission of the court, by the court itself of its own volition if it's requested. That generally happens when there's a settlement, like an accident or something. Or they can be created by the beneficiary, assuming that the beneficiary has capacity to do so. There is something called the sole benefit rule that first-party trusts are subject to. And the sole benefit rule says we have to operate this trust and make distributions from this trust for the sole benefit of our primary beneficiary and not for anyone else's benefit. Ultimately, at the end of the child's life, because we're using first-party money, the child's money, to fund this trust, the remaining funds in that trust are going to be subject to Medicaid payback. So this is the primary reason that this is not a great estate planning trust. We don't want to go out of our way to put our money into the first-party trust. We just want to put the child's money in there. And then once we've funded the first-party trust, it's the first trust that we'll use assets from, because anything that's left over is going to have to go to reimburse Medicaid. And that's not most people's ideal plan. The first-party trust must be irrevocable on the day that we sign it, meaning we can't undo it later. We can't put money in there and then take it out. Once it exists forever. It must be an inter vivos trust. Inter vivos means during life. So it must be created during life instead of being a testamentary trust, which we'll talk about later. First-party trusts cannot be created or funded for a beneficiary who is over the age of 65. There's an interesting little planning trick that we can do if our facts work out properly. You can fund a first-party trust for some other beneficiary other than yourself if you are older and you are looking at going into a nursing home and you want to qualify more quickly for nursing home Medicaid, which is a different type of Medicaid. There is also a means test for nursing home Medicaid, and Medicaid has a 5-year look back for any gifts that you make. But an exception to that look back period is if you fund a first-party special needs trust for someone else's benefit, then Medicaid does not employ the 5-year look back period for that transfer. So you could fund that trust and immediately become qualified for nursing home Medicaid. So sometimes we use that as a planning technique if we have an older family member, usually a grandparent, and there's a grandchild who has special needs. We can have the grandparent fund the first-party special needs trust, immediately qualify for nursing home Medicaid, and then we have another whole lifetime to use up that money before we have to worry about the Medicaid payback. So the first-party trust, as I said, is essentially a damage control trust. I love these trusts. I think they have a lot of uses, but they get sort of a bad rap because nobody likes the idea of paying Medicaid back at the end of the child's life. But, sometimes you just need one. It is what it is. So sometimes those are appropriate. If you're looking at doing conventional estate planning, though, and you have a child with special needs, the type of trust that you're going to be interested in using is called a third-party special needs trust. Sometimes these are called supplemental needs trusts because they are designed to supplement and not supplant any benefits that your child might receive. So the third-party trust can hold assets from anybody in the world except the beneficiary, which makes them a much more popular vehicle and a more useful vehicle if you've got family members who want to contribute to the care of your child. So they can also be created by anybody except the beneficiary. So if we don't have surviving parents, for example, a sibling could create a third-party special needs trust. So we have a lot more flexibility with regards to that. The big thing that makes third-party trusts appealing is that there is no Medicaid payback out of these trusts at the end of the beneficiary's life, which means if you create a third-party special needs trust for your child, and then at the end of the child's life, we still have assets remaining, those assets go wherever you say they go. So that's why this is sort of the classic estate planning trust. A lot of times parents, with that in mind, will superfund the third-party special needs trust, so they'll direct a greater proportion of their assets to that trust than they will to maybe other kids in the family. And they will figure, if my special needs child needs this money, I want it to be there. If we don't need it all, at the end of that child's life, the remaining assets will go to the other kids or to their kids. So that's something that people think about sometimes when they're figuring out how to designate assets among their children. The third-party trust can also be either revocable or irrevocable. So we have a lot more flexibility with our planning. Typically, I like to make these trusts revocable in the initial signing phase, because that allows us to amend the trust so that if laws change, we can, add provisions or change provisions so that we're always in compliance with the law. Or another thing that people often do is, years go by and maybe somebody who they thought would be a great successor trustee has turned out not to be so great, and maybe they're not as reliable as we thought they were. So sometimes parents will come back after a period of years and they'll say, we want to revisit all of our successor trustee designations, and we want to add some people or take some people out or change the order of the people that we have. So if the trust is revocable, it's easy to do that. It's easy to make any kind of change you want anytime you want to, until one of our triggering events happens. And one triggering event that will cause the trust to become irrevocable is the death of the grantor, the person who creates the trust. Sometimes if we have a situation where a family is wealthy enough so that they have estate tax issues, which isn't really a thing for most people in America these days. I think it's something like 0.5% of the population has to worry about estate taxes. So, most of us are just not wealthy enough so that we care. But if the exemptions from estate tax drop, or if you are one of those families that's wealthy enough to care about tax planning, that would be a good reason to make our third-party trust irrevocable, because then you can do lifetime gifting to the trust in a manner that gets those assets out of your taxable estate. So that's something to talk to a planner about if that's where you are. But that's just an example of why we might want to make our trust irrevocable if we're in that situation. Third-party trusts, unlike first-party trusts, don't have to be inter vivos trusts. In other words, they don't have to be created during life. They can be either inter vivos or testamentary. A testamentary trust is a trust that exists under your will. So that's not my favorite way to do this, but we can do it that way if we really want to. If we do it that way, then we just create a sub-trust under the will that says, I leave all of this child's assets to this third-party special needs trust that's created under this will. The downside to doing a testamentary third-party special needs trust is that nobody else can use it. You don't really have a trust until you die. So that means grandma and grandpa can't leave things to it. People can't make gifts to it. You can't make a gift to it while you're still here. It doesn't really exist until you're gone. So the inter vivos trust, on the other hand, can be used by other people in the family who might want to make gifts to take care of your child, or who might want to name the trust for the child as the beneficiary of, a life insurance policy or a retirement account or something else. A lot of my older families with older parents, also like the idea of creating an inter vivos third-party special needs trust, because they can open a bank account and make gifts to that trust, even if they don't have any estate tax issues, because, when somebody passes away, all of their assets don't end up where they're supposed to go in 24 hours. It can take weeks, it can take months before the executor can, collect all the assets of the estate and put them where they're supposed to go. So in the meantime, if there are no other assets to take care of the child, that could be a problem. So if there's something in the trust already at the death of the parents, then we've got money to sort of keep us going until the executor can collect all the estate assets and put the child's assets into that trust. There is no age limit for a third-party special needs trust. You can create one for anybody of any age. You can fund it for anybody of any age. So that age 65 provision that applies to first-party trusts does not apply here. I love all the flexibility of third-party trusts. One of the things that we can do, and that I often do when I create one of these, is I allow the trustee to own a home, and I allow the trustee to give our special needs child permission to live in the home and either to charge rent or not at the trustee's discretion. And there might be good reasons why we want to charge rent. So for example, if we've got a child who is terrible with money and he's got, by the time his parents pass away, he'd probably be on SSDI rather than SSI. If he's getting, it could be as much as $1,500 a month or more if they're on SSDI, then we don't want the child to have control of that money if he's vulnerable to predators. We definitely don't want to build up more than $2,000 in the child's bank account, because even though SSDI is not a means tested benefit, there are lots of good Medicaid waivers out there that we still care about. So to keep the bank balance low, to take the money out of the child's hands and put it into the hands of the trustee. For other reasons, if the child is on SSI, we don't want to have a 1/3 reduction for in-kind support and maintenance if we let the child live somewhere for free. So we charge rent to keep the child getting the full SSI amount. So for all of these reasons, the trustee might want to charge the child rent, and in that case the child is paying rent to this basket that's there to hold assets to take care of the child. So there's really not a big downside to that. The third-party trust can hold anything that anybody wants to put into it, except for something that belongs to the child. So the third-party trust can be the beneficiary of a life insurance policy. It can be the beneficiary of an IRA, which is a fantastic plan, especially since the beginning of 2020, because of this Secure Act. I'll just do a little aside on the Secure Act because a lot of people don't know about it yet. It was passed into law at the end of 2019, and it actually became effective in January of 2020. And its impact was to dramatically change the way that we can handle inherited IRAs. So in this post-Secure Act world, anybody who doesn't meet one of 5 exceptions to this rule has 10 years to cash in an inherited IRA and spend all the money, and pay taxes on the money. They don't have to spend it, but they have to take the money and they have to pay income tax on it, and they have to pay that income tax at their marginal income tax rate. So the old rule was that if you inherited an IRA, you could stretch the IRA out over your actuarial life expectancy. So there are still some people who are allowed to do that. A surviving spouse is still allowed to stretch an inherited IRA, and a disabled beneficiary of the IRA or a trust for that child or for the adult, whatever they are at the time they inherit the IRA, is also allowed to operate under the old rules, which means if you have a child with special needs and you leave your IRA to their special needs trust, we have that child's actuarial life expectancy instead of 10 years to stretch out our distributions from that IRA, which means we can take smaller distributions every year, and any income tax that we do trigger is likely not to be a super big deal because your special needs child is probably going to be the lowest income earner in that generation of children. So there are significant income tax planning benefits to leaving an IRA to a third-party special needs trust thanks to the Secure Act. So just to summarize the various sources of funds that we can use to fund a third-party special needs trust, of course you can use assets in your estate. So you would create this trust and then your will would say, my assets that are going for the benefit of this child, my special needs child, don't pay those to the child, pay them to the then serving trustee of the blah, blah, blah special needs trust, so that they're held in a manner that prevents them from eliminating the child's eligibility for means-tested benefits. As I said, you can name a third-party trust as the beneficiary of a life insurance policy. You can name the trust as the beneficiary of retirement accounts. Friends and family can also contribute to this trust either during their lifetimes or in their own estate plans. I mentioned life insurance. This will be my last big thing that I hit on today. There are a lot of people who will insist that whole life insurance or permanent life insurance is just evil and it's a crazy waste of money and nobody needs it. And, that might be true for lots of people. It is not true if you have a special needs child, unless you have enough assets from other sources to completely take care of that child for his whole life. So special needs families are not Clark Howard families. A lot of special needs families, especially if you're young enough so that it makes this really affordable, a lot of special needs families will purchase a permanent life insurance policy. Yes, it's more expensive every year, but eventually you hit a point where you have paid enough premiums to that policy so that it just takes over and the premiums begin to pay themselves. And that policy is then in existence for your whole lifetime. So term life insurance reaches a point where the term is up and you don't have any insurance anymore. And even if you have a term policy that goes to some advanced age like 95, what you may find is that as you get older, the premiums for that policy go up and it becomes prohibitively expensive for you to pay for the premiums of your term life insurance. And at that point, you're really too old to go back in time and get a permanent life insurance policy. So if you are not sure how you're going to fund your child's special needs trust, if you don't have enough resources so that you know that a portion of your estate or even all of your estate will be enough to take care of your child, it's a great idea to look at life insurance and to have a permanent life insurance policy that's headed straight for your child's third-party special needs trust at your death. So that is everything I have to say, at least in the time that I have here, about special needs trusts and the funding of special needs trusts. I hope this has been helpful, and best of luck to everyone. This can be very stressful, special needs planning, but I personally find that it's such a relief to people when they've gotten it done. It's nice to be able to check off that box, and then you can pick something else to worry about at 2 o'clock in the morning when you wake up and can't sleep and start thinking about what's going to happen far down the road in the future. So best of luck to everyone, and everybody stay safe, stay healthy.